Brighten your day. All right, the court is calling 2024 CR 012487 State versus Philip Pettis. Can I have parties announced?
State.
It's Fernando Cortez for Mr. Pettis.
And are you Mr. Pettis?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
I have your honor.
Court will find that the state is in compliance with discovery. And counsel, in this case, was there ever a mental health evaluation?
Yes, we just came from that court maybe a week ago, judging and found competent, but with significant issues.
All right. All right, Mr. Pettis, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading?
I waived reading, your honor.
State, are you proceeding on the indictment as presented?
We are proceeding solely on count one, waiving count.
Any objection?
No objections, your honor.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? All right, you're charged with theft of property more than $300,000. That's a first-degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
You have, your honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, your honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, your honor.
Mr. Pettis, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count one. They're waiving count two. They're asking that your punishment be assessed at 18 years in the prison. There's a $1,400 fine, no applications. This will run concurrently with the case out of Kendall County, case 9493. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, your honor.
State?
Yes, ma'am.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, your honor.
Then to the offense in count one, how do you plead? Guilty, not guilty, or no contest? State any evidence.
No objection, your honor.
All right, and state, was the vehicle returned? All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state will call in the right to cross-examine any witnesses and the right to remain silent.
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will find you guilty. Are you proceeding with sentencing?
Yes, your honor, please.
Right. So, Mr. Pettis, why did you take an ambulance?
I was just going crazy. I was like mad.
Okay.
And that's one of the issues with the competency judge. He got serious prior diagnosis He was found competent, and I think he was homeless at the time that this occurred and was not taking meds and stuff, so that's kind of what happened.
Okay. And what is the the Kendall County case? Okay. All right, thank you, State. All right, this is what the court is going to do. The court is going to sentence you to the 18 years, give you credit for any time served. This will run concurrently with your cases in Kendall County. And that's case number 9493. I'm going to request the therapeutic community, and there's to be no residing in households with minors. Did you review the trial court certification of defendants' rights to appeal with your attorney? Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing.
May I mention one thing, Judge,
Yes.
please, on the record that?
Okay, on the record?
Yes, Your Honor, please. He was already at TDC, and we're simply asking for the court to indicate on the record that the time that he got here would run concurrent with any TDCJ obligations or time.
Well, I mean, the only thing I can do, because I don't know the time frame of that, the clerks will be able to look it up in the system. What I can tell you, while this case has been pending, right, you had a warrant for this case, you will receive credit from that day. Okay. All right. So here's the thing. The state waived the habitual enhancement. If they would not have waived that, your minimum would be 25 years. So when you're released from custody, the first thing you need to do is go to the Center for Healthcare Services, tell them you need a case manager, and let them know when you leave the prison, they will give you your diagnosis if you request it. So make sure you request that and make sure you have a plan. You understand? All right, good luck to you, okay?
Thank you.
You're welcome.
In life, just one wrong decision can plunge you into darkness for years. Ignoring mental health is sometimes even more dangerous than crime itself. Philip Pettis stood before the court charged with theft exceeding $300,000, a first-degree felony that carried the possibility of 5 to 99 years or life in prison. At first, the hearing appeared routine, with the state presenting a plea bargain recommending 18 years and a $1,400 fine. But as the session progressed, it became clear this case was far from ordinary. The judge carefully questioned Philip, discovering significant mental health issues and noting his homelessness at the time of the offense. He was not taking medications. "This is serious," she acknowledged, immediately setting a tense and suspenseful tone. Philip confirmed he understood the indictment and voluntarily waived his right to a jury trial, the right to cross-examine witnesses, and the right to appeal. As the plea was read aloud, the courtroom held its breath. Philip accepted the state's recommendation of 18 years in prison, running concurrently with a previous Kendall County case. The judge, maintaining strict professionalism, explained the waived habitual enhancement meant a minimum of 25 years was avoided, but still emphasized the gravity of his situation. "Make sure you have a plan and request your diagnosis upon release," she advised, signaling both stern justice and a path to rehabilitation. The courtroom's atmosphere shifted from procedural to emotional as Philip realized the full consequences of his plea. The combination of homelessness, mental health issues, and serious felony charges created a scenario that left everyone stunned. Ultimately, the case demonstrates the power of judicial discretion and the weight of criminal consequences. It's a stark reminder that legal decisions are rarely simple and that even routine pleas can carry life-altering outcomes. This case leaves viewers viewers questioning the balance between mercy, justice, and accountability, showing the real human impact behind courtroom drama. The state waived the habitual enhancement, otherwise your minimum would have been 25 years. The judge's words echo, highlighting the tense stakes and Philip's life-changing decision. If you want to watch more real-life courtroom cases, make sure to like the video and subscribe to the channel. And let me know in the comments, do you think Brandon should have gone to jail, or was treatment the right decision?